Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I want to talk about a particular aspect of domestic assault law, but it also applies to other instances, but particularly I see it coming up in domestic assault, domestic violence cases here in Virginia, about what you said to law enforcement and whether or not it matters. Oftentimes people will call me, tell me that they've been charged or accused and charged of a domestic assault or domestic violence charge. And they'll tell me what happened and they'll kind of run through things. And in many instances, they'll say they're not guilty and it's being alleged wrongfully and fabricated. And then I'll ask them, well, what did you say to law enforcement? And they'll kind of look at me confused and say, well, why does that matter? And the reason it matters is it's super important because any statements that you say to law enforcement can and will be used against you in court. So long as law enforcement properly asked you questions, and whether or not they questioned you legally, that's subject for another video. But if they legally asked you questions and you made statements that essentially admit or confess to the crime that you're alleged, particularly an assault case, that can be truly damaging to a defense. The way the law works is if you made a full confession of a crime, let's say you admitted to assaulting and slapping another person outright to law enforcement, then the only thing that a court needs to find you guilty of that charge is what they call slight corroborating evidence. Now, what that actually means is up for question, but as you might expect, doesn't sound like a whole lot. At least that's the way the language is used in the law and the cases. So, and also if you've admitted to certain elements of the crime, but you haven't given a full confession, those statements can still absolutely be used against you and be very damning in a charge, an allegation against you of a domestic assault. Where I see this play out a lot is situations where there's some type of altercation between significant others. A call is made to 911. The complaining witness has alleged an assault. The accused is then questioned by law enforcement, and they make a statement that can be used against them. And then we come to court, and the complaining witness has decided they don't want to go forward. They don't want to testify. They want the case dropped. Either they've acknowledging that they've misrepresented what happened, or for whatever reason they've chosen not to go forward, and those motivations is subject for another video. But in many instances when this happens, I have to advise the client that I'm representing, if they've made these damning statements, that even if the complaining witness doesn't want to testify, or if their testimony is limited, my client, the accused's own statements can still be used against them, and it still can be very, very convincing to a judge or a jury that there is guilt beyond a reasonable doubt. So if you've made statements to law enforcement, number one, you need to tell your attorney. The worst scenarios I have is where an accused, I will represent them, they won't tell me of any statements made, and I don't find out about the statements made until later on in discovery, or some scenarios, which this shouldn't happen, but some scenarios at trial where I've now learned that they've confessed to a crime or admitted to a crime, and now my analysis has changed a lot, significantly. So the other thing is this is really perspective. If you're just trying to learn about criminal law and being accused of a crime, you're not required to speak to law enforcement. Okay, if law enforcement asks you to just sit down and talk with them and just tell us what happened, you're allowed to assert the Fifth Amendment. You're allowed to ask for attorneys, and you're allowed to remain silent. The Constitution provides a Fifth Amendment right to not incriminate yourself and to remain silent, and that silence cannot be used against you in court. So if you know law enforcement is coming, my recommendation would be to assert the Fifth. You don't have to be a jerk about it. You can simply say, I'm asserting my Fifth Amendment right to remain silent. I have nothing to say. Now, they may say to you, well, we're going to arrest you. If that happens, it happens. In my experience, that threat of arresting you if you don't make a statement, you were likely going to be arrested anyway. So I don't think you lose a lot. And then asserting a right to counsel before you're questioned again, just to make clear to law enforcement that you're not making any statements. Hopefully this is useful information. If you have more questions, make sure to check out our website at www.abreniolaw.com. You can also give me a call at 703-570-4180. Look, domestic assault charges, domestic violence charges obviously are very serious. There's a lot of implications that surround just being alleged of a domestic assault or domestic violence, and they can have life-changing consequences. So you need to make sure that you're properly educated before you go to court. In my view, that means talking to an attorney specifically about your case and getting specific advice and making sure that you hire the right attorney if you have the availability to do that or ability to do that. Don't just rely on a YouTube video or a web page. You need to be educated and prepared to defend yourself. I hope this video is useful. If you have any other questions, let me know. Thanks.